Welcome to our video series, Data Act Unlocked. In this series, we provide a concise overview of the most important provisions of the EU Data Act. In this episode, we will take a look at the enforcement provisions of the EU Data Act in Chapter 9. The EU Data Act is an EU regulation and applies directly to all EU member states. This episode covers the competence of national authorities, the right to lodge a complaint, the fine system, the obligations of companies not established in the EU, and the advisory role of the European Data Innovation Board. The member states of the European Union are responsible for implementing the EU Data Act. Each member state must establish one or more competent national supervisory authorities. Where more than one authority is designated, a national data coordinator will also be appointed to coordinate the activities of the supervisory authorities and serve as a central point of contact for questions relating to the application of the EU Data Act. The EU Data Act is enforced exclusively by the national supervisory authorities in the EU member states. According to Article 37, Section 5 of the EU Data Act, the supervisory authorities are responsible for handling complaints about infringements, imposing fines for infringements, and raising awareness of the obligations under the EU Data Act. Supervisory authorities may act either on their own initiative or on the basis of a complaint. Data subjects have the right to seek judicial remedy against the authority's decisions. This right also applies if the authority fails to act on a complaint. According to Article 37, Section 10 of the EU Data Act, the supervisory authority in the member state where the company is established is competent. If a company is established in several EU member states, the authority of the head office is competent. Although there is no central enforcement authority at the European level, the European Data Innovation Board, EDIB, which was already established under the Data Governance Act, will fulfill an advisory and coordinating function. The EDIB is composed of representatives of the national supervisory authorities, the European Commission, the European Data Protection Supervisor, and other specialized institutions. In particular, the EDIB's tasks include promoting the consistent application of the EU Data Act, developing guidelines to harmonize enforcement practices, and advising the Commission on technical standards and interoperability issues. However, the EDIB has no decision-making or enforcement powers. Responsibility for enforcement remains entirely with the national authorities. Infringements of the EU Data Act may result in fines. According to the regulation, these fines must be effective, proportionate, and dissuasive. However, the specific amount is not set at EU level, but left to the member states. Unlike the GDPR, there is no uniform framework for fines across the European Union. Nevertheless, Article 40, Section 3 of the EU Data Act sets out several criteria for determining the amount of fines, including the nature, gravity, scale, and duration of the infringement, any previous infringements and actions to mitigate the damage, financial benefits gained, and the annual turnover achieved in the European Union. If infringements of the GDPR are identified in connection with the enforcement of the EU Data Act, the fine provisions contained therein apply. These contain fines of up to 20 million euros or 4% of global annual turnover. The scope of the EU Data Act extends beyond companies based in the European Union. Companies based in third countries that offer products or services in accordance with the EU Data Act within the European Union are also required to comply with its provisions. Specifically, this means that any company without an establishment in the EU that provides connected products or related services on the Union market must appoint a legal representative in the European Union. This representative acts as a point of contact for national supervisory authorities and must provide evidence of compliance with the regulation upon request. The representative may be based in any EU member state. Supervision is then based on the representative's location. If no representative is appointed, all national supervisory authorities can take action. Therefore, companies that do not appoint a representative do not benefit from a concentration of competence. As the representative can be appointed in any EU member state, appointing a representative can also be used tactically to establish the competence of a specific supervisory authority. Please note that even if a representative has been appointed, the company remains liable for infringements of the EU Data Act in accordance with Article 37, Section 13 of the EU Data Act. To wrap up, here are the key takeaways from this episode of our new series, Data Act Unlocked. Member states must designate an enforcement authority. This authority will impose effective, proportionate, and dissuasive penalties for infringements of the EU Data Act. These penalties may include warnings, orders, or fines. Companies not established in the European Union must appoint a legal representative. We're glad to have you following our series Data Act Unlocked. For more insights, check out #CMS Data Law or visit our website.